Mr. Will Sleeth is an attorney with the law firm of Gordon and Rees, a full-service national law firm with over 1,000 attorneys in all 50 states. Will leads the firm's National Community Association law practice, and Will practices out of the firm's Williamsburg office and represents associations all throughout Hampton Roads. Mr. Rich Shermer, works in business development and association management for the United Property Associates, where he has been employed for over 10 years.
Well, good morning or good afternoon or good evening, everyone, and
As the case may be.
thank you for watching our presentation. We're going to do our best to try not to bore you, because what normally Rich and I have presented in the past, and normally you're a captive audience at the Virginia Beach Convention Center because most people feel it's too rude to get up and walk out in the middle of a presentation. However, if you're watching from home, you can turn us off at any time you want. So we need to up our game this year and really try not to bore you.
That's it.
So thanks for choosing our presentation, and we're going to be presenting about politics and political signs and HOAs. So if you're following along in your slide deck, the second slide is a disclaimer that nothing we say here should be construed as legal advice. We're going to be talking about the law at a very general level, but when you encounter specific legal situations, you should always consult with your association's legal counsel and do not rely on anything we say as legal advice. So, Rich, do you want to kind of tee up this topic for the folks to what we're going to be talking about?
Sure. We just came through a national election, and what condominium associations and homeowners associations typically face is all of the supporters in the community for one candidate or the other, or several of the candidates, will want to show that support. And what we're here today to discuss is how to approach that from the association standpoint. What can, should, could be done in terms of monitoring or enforcing regulations for political signs.
Yeah. Great. So I think this is a real timely topic. We're just coming out of the 2020 elections, and Virginia has elections this fall for statewide office. So we don't get a break here in Virginia. It just keeps going. It seems like it's constant election season. So that being said, let's launch in. The next slide talks about promulgation and adoption of political sign rules on owner lots units. So what is the current state of the law in Virginia on this issue? Well, Virginia law provides a very large degree of authority to associations to regulate or outright prohibit political signs on owners' lots or units. Associations have the authority under the law to completely prohibit all political signs if they want, or they can not outright prohibit them, but regulate them and say you can only have some of a certain size or
Certain
number posted in a certain place. Now, please keep in mind, the law in Virginia is a little different from the law in some other states. There's some other states, such as New Jersey, for example, that actually have much more heavier restrictions on what associations can do when it comes to regulating political signs. There was a New Jersey Supreme Court case a few years ago that really limited associations' ability to regulate political signs. In Virginia, associations have much more freedom, and so please keep that in mind as you go forward. Now, one of the things owners often say is they say, well, what about the Constitution? What about my First Amendment rights? Have you ever heard any owners raise that to you?
all the time.
Yeah,
All the time.
Yeah. And this is something that you as board members and community managers should be aware of, because you're going to get this question. They say, what about my First Amendment rights? The important thing to keep in mind is this. The First Amendment to the United States Constitution applies to governmental action. And community associations are not governmental actors. Rather, they are private entities that people voluntarily join. So the theory behind this is, if you decide to voluntarily move into a community association that has these restrictions, or that has a document regime in place whereby they can adopt the restrictions, you are voluntarily giving up your First Amendment rights, and you have to live with the consequences of that. So when you get that question, I recommend that you patiently explain to the owner how that works, because they love to throw that out there, and
They will.
yeah. So what Rich and I want to do is we want to talk about a new law that the General Assembly adopted the other year, that while it doesn't really tie the hands of associations with respect to political signs, it's something associations should be aware of. So if you go to the next page in the slides, there was a new law that was adopted by the General Assembly the other year that states that in your disclosure packet or a resale certificate in the condominium context, associations are required to disclose the existence of any regulations the associations place on political signs. You know, if you're a smaller community, or I mean, certainly if you self-manage, you may not necessarily be aware of this. So I'd encourage everyone to really check their disclosure packets or resale certificates to see if you have a provision to this effect in there, because it's now required by law. Rich, what have you been seeing on this standpoint? Have most associations been on the ball on this point?
Pretty much. I mean, the associations that I've been directly involved with have adopted sort of a, the standpoint that we're not, unless it gets excessive, they're not going to overly control or dictate rules on signs. There are existing rules, and you'll come against us in a lot of legal documents for associations. There'll be restrictions on signs, not political signs. And to the extent that owners don't take way too much advantage with this, the boards have basically said, let's just stand back, and we understand this is going to be maybe a 45-day sort of process. And it's like, what battle do you want to fight?
Yeah.
And what's the cost benefit? And so they're trying not to be draconian, and they're trying not to get dragged into what is almost inevitably going to be a personality situation from one owner to the next.
Yeah. It's also interesting because this last election season, I saw a handful of communities of mine that were wrestling with this, and they said they really wanted to enforce it. By the time they sent a violation notice, a second notice, and called the owner to the due process hearing, the election was over and the signs were going to come down.
Exactly.
And so we really had to wrestle with this dynamic of, do we start the enforcement process when it all may be moot at the end of the day? And kind of one of the concerns that we'll get to towards the end of our presentation is, do you risk a waiver of the governing documents if you don't enforce it? And so the thing I advised a lot of my communities was, if you have a restriction in the governing documents, you should either enforce it or remove it from the governing documents. But by keeping it in there and not enforcing it, you run the risk of legally waiving it. And we'll get into this more towards the end of the presentation.
And I think that's a great point. I think that, going back to literally the M100 course that we all take, every rule has to be, made in a way that it can be enforced equally, that it is fair. And that way, you get away from getting dragged into what could be, one owner against another, and then dragging the board and the association into whatever kind of conflict that you really don't want to get into.
Yeah, good point. On the next slide, we want to educate you about a bill that was proposed before the General Assembly the other year that did not pass. But it's a significant bill, and it's something that's probably going to come up again, so it's important for you to be aware of this. This bill that was proposed, but this was not adopted. This is not law, what we're talking about. What this bill provided was that if associations are going to regulate political signs, the regulation provision has to be in the declaration. It cannot be in the rules and regulations. This is significant because most of us know that it is significantly easier to amend the rules and regulations, which can usually be done by a vote of the board, compared to amending the declaration, which involves almost always a community-wide vote, a new amendment drafted up, recorded in the clerk's office, and it's 10 times more burdensome than just a rules and regulations amendment.
And in some cases, excuse me, that also might involve the mortgagees.
You're right.
I'm sorry. Yes, the mortgagees.
Yes.
So that's a very high bar for any association.
Right. Rich is alluding to getting mortgagee consent and the cost involved in that. Oftentimes you have to do a title search of all the lots to find out who the mortgagees are. You have to mail out the notice to the mortgagees. Many mortgagees will charge a fee to process that. And while there is a code provision in the POAA Act and the Condo Act that allows you to rely on silence for mortgagees after a set time period, that drags out the process even more. And so there are a lot of challenges on this front. So this bill is going to have some pretty significant impacts. I'm not going to read the whole text of the bill to you. It's available in the PowerPoint slides for you. But suffice it to say, it was going to significantly upend this area of law in Virginia. Now, that did not pass, but Rich and I were chatting about this earlier, and we were talking about how we think it's probably just a matter of time before a bill like this comes back.
I believe that's right. I've never seen an opportunity where the General Assembly just can't, will give up an opportunity to install more regulations for our industry, or at least try. So yeah, we may have dodged the bullet last year, but yeah, it'll probably come back.
Probably. Probably. So, next slide. In this slide, we talk about the promulgation and adoption of political sign rules on common area elements. So, before we were talking about how associations have very broad leeway to regulate political signs on owners' lots or units. Now we're talking about on the common area, or in the condo context, common element. Rich, what are some things that you see from associations when it comes to political signs on the common area, the common element?
Well, in general, that they don't allow that. There are plenty of opportunities, and for folks to express their opinions on their own lots, that may be a little bit tough on for condominiums because even the lots are common. But when I think of common elements or the common areas, I'm thinking about the green spaces, the median areas, the cul-de-sacs that may have planting areas, and they generally frown on that in a big way.
Yeah. And it's easy to understand why, right? You drive down a highway, some stretch of these highway, you can see 50 signs in like a 30-foot stretch. It's littered, it's junky, and that's really not what we want in our community. So I think both of us would advise against allowing owners to put political signs in the common area, in the common elements. Now, that said, if you really want to do it for some reason, it's important that you have a neutral policy in place. In other words, you can't say only Republican candidates or only Democratic candidates. You can't say, only candidates who last election got at least 1,000 votes. There's all sorts of things you could try and come up with. If you decide to do it, it should be on a neutral basis. And I think limiting the number of signs would be prudent so that it doesn't become the junky highways that we're all used to.
I agree. I would waive any board of directors off from going there, but if you want to go down that rabbit hole, do it with your attorney. Craft a rule, again, that is fair and enforceable. Otherwise, you're literally begging for trouble.
Yeah. Let's go to the next slide now. This slide touches on opening up association common area or elements to political candidates. So the most common example is probably the clubhouse, or maybe a green space with a gazebo. Rich, what do you see associations doing? Do you see associations inviting political candidates? Do you see them allowing political candidates who want to come on the common area? Are you seeing this much?
saw it a little bit. One of my communities has a lot of green space, and the board of directors basically said, look, if an owner wants to organize something, bring a candidate in, that's fine. But the board did not give official sanction to the event. So they need that separation so that they're not officially sponsoring any one candidate over the next, because dollars to donuts, somebody's going to come back and say, well, I wanted to have my campaign event there, and I wasn't able to. Well, okay.
I think that's wise. And from a legal standpoint, I would recommend that associations avoid themselves inviting candidates onto the common area. In other words, this is an invitation from Shady Meadows Association to this candidate or all these candidates. Now, you may say, well, can we invite all the candidates? I'd still recommend trying to avoid that from the association's perspective, because what you'd first need to do is you really need to check the association's corporate documents to see if it even gives the association the corporate authority to engage in political affairs. It very well may not. There could also be tax treatment that could be implicated too. And so if you're thinking about going this route, you'd want to talk to the association's CPA to be aware of whether there could be any tax implications from the association itself inviting folks on. Now, let's talk a little bit about not the association inviting folks on, but owners saying, hey, I want to invite candidate Joe Schmo on. In my opinion, I think that would be okay as long as the association has a neutral all-comers policy. In other words, if Mary Smith wants to invite Joe Schmo on, then Joe Johnson has to invite John Schmo on. You know, anyone can invite who they want on. It's not the association doing the inviting. Rather, it's just the association making the space available for enforcing. And I think that's kind of what you were getting at, is you were seeing.
Yeah, I think that's right. The only, because if the association gets involved, then my first thought is going to be, what are the insurance implications, among others, right? You have a political event at your clubhouse or one of your big green spaces, and somebody gets hurt somehow or another. There's a trip and fall, or things get a little out of hand. They get heated. Mm-hmm. Then what? So yes, I would say it's big laissez-faire. Yeah. Let the owners take care of that on their own.
Yeah, I think that's wise. And if it's at the clubhouse and the owner's renting the clubhouse, you'd want to enforce your regular rental policies, which may include requiring the owner to get insurance and name the association as additional insured.
Correct.
Sign an indemnification agreement whereby the owner will indemnify the association for any damage. So good thoughts on that front. Let's go to the next slide. And this next slide talks about the distribution of political information. And so, Rich, here's the question. Should the association allow candidates or supporters of candidates to come on association common area and start passing out political literature? Have you seen that going on in any
I actually haven't, no.
Okay.
And I, again, on an official basis, I would say no.
Yeah.
And I hate to be that guy, but it's just so fraught with potential liability one way or the other that on an official basis, no. The association shouldn't get into that business.
Yeah.
Doesn't have that. I don't think it needs to go there.
I think it's prudent to avoid associations inviting people on to hand out paraphernalia. Now, there's a different issue of the association is not inviting them on, but should it allow people to come on to the common area, the common element, and hand out pamphlets? And this, in my mind, is going to trigger a lot of non-solicitation provisions that are either in the declarations or likely in the rules and regulations. Mm-hmm. And if an association doesn't have a non-solicitation policy, it should probably adopt it. Not necessarily just for political reasons, but just for pesky salesmen going door to door. So if from a legal perspective, could an association let pamphleteers come on the common area? I suppose they could. I don't think it's smart though, and I could see it creating a lot of problems and some of the same issues that we talked about with respect to hosting the campaign events.
I think, well, you hit on a good connector there that may not be, intuitive with a lot of folks, and that is that there are a lot. We have all gone through the non-solicitation situation, or most of us have, because you don't want people knocking on doors. In my own association where I live, they have non-solicitation policy. That can extend to the political candidates coming in and doing the grandstanding, the pamphlet handout, whatever. They're connected. So if you've got that, you're not you're covered, and you're not having to run the risk of saying, well, you're discouraging my candidate. No, I'm not.
Yeah.
No candidate's supposed to be doing that, and that's the way you need to be.
Yeah. Let's talk about a scenario whereby an owner comes to the board and says, hey, I know on the association's website we have all sorts of information. I would love to post information about candidate Joe Schmo there. Will you let me do that? My thought is kind of the same thing we've been talking about. I don't think it's prudent to open that door. If you did open that door, from a legal perspective, you would need an all-comers policy. You need to allow any candidate kind of equal opportunity, equal space, and equal time to do that. But I'd really encourage associations to seriously think through whether you want to open that Pandora's box, because it's 90% of the time going to be more problematic than beneficial. What do you think, or what?
Totally agree. And I think that if you wanted to go there, and I'm not sure how you would do it, but I think that the association would have to demonstrate somehow or another that it has an all-comers policy, that it's taken whatever, past the reasonable man sort of test. It says we've demonstrated that anybody can post their political jargon, whatever it is, on the site, and that way, if you wind up with all one party and not so much the other, then you can't be, sort of seen as falling for one party or the other.
Yeah. Good point. Rich, our next slide is kind of a catch-all of other issues. Are there some other issues that you've seen, whether in the 2020 election cycle or past election cycles in your communities, that come up that would be helpful for our viewers to kind of hear our thoughts about?
I think, yes. I have a couple of kind of neat war stories.
Please, yeah.
One association, and I do not manage them, but was petitioned by one of the owners who filed a complaint against a fellow owner because the political sign was visible from the neighboring property. The neighboring property happened to be the creek, the navigable creek in back of the property. And when one was in a boat in back of this lot, they could see the candidate's sign. And I'm not making this up. Couldn't make that up. The other issue that it came up against is, in those associations where flagpoles are permitted. One in particular, there were signs everywhere on people's lots, according to what they were allowed to do, and expressing their thoughts. One guy had a flag, a campaign flag, and his was the source of most of the complaints that I got about the political signs in that community. What I would advise is simply, the board is there to be a good steward of all of the resources for the association, and hopefully that means the relationship side too, that the board has a good enough footing with the owners to say, guys, can we just sort of take a step back and breathe and figure this out without having to come up with some dictatorial draconian kind of rule and reg. The other thing that and part of that issue, I think, means communicating ahead of time. One of my communities is so good with their platform, their association platform, and they have 98% or something like that of the unit owners' email addresses that they will put out there for consumption, you know, 'tis the season kind of a thing.
Yeah.
Let's all remember to, be considerate of everybody and, all the opposing views, whatever they may be. And getting out ahead of it, I think, takes care of, probably 50% of your potential problem.
Yeah. Good thoughts. Good thoughts and good points there. So, our next slide is titled Keeping the Peace in the Community. And this kind of raises two issues. Are there things we can do to kind of be proactive before election season? And also, after election season, if there's kind of bitter feelings, what can we do to kind of smooth over feelings? What have you seen in associations of yours over the years on these points?
Mostly what I've seen, in the aftermath, I think I spoke a little bit to the proactive side of things with communicating and making sure people understand where the board on behalf of the association is. Where I have seen some of the animosity is if somebody doesn't, get rid of their sign, 2448, whatever the number is, you can bet that somebody's going to be almost, using a stopwatch on a neighbor whose sign they may not agree with. And if the association isn't on it, then it's going to come back in the form of a complaint, almost guaranteed. So I think that's been probably the most prevalent for me, is if you're going to allow signs, fine. If they need to be picked up, withdrawn, taken inside, whatever it is, make sure that they're adhering to that as well.
Yeah. Wise words. Wise words. This gets us to one of our final points on the slide titled Issues Surrounding Enforcement. And I want to take a few minutes to kind of talk about the legal implications of enforcing or not enforcing sign restrictions. I often encounter associations who come to me and say, hey, Will, we have a really restrictive sign provision in our declaration. We don't want to be that harsh, or that we don't really want to enforce it as fully. So we're just going to take a more lax approach to enforcing it. The thing I always tell them is, I say, look, if there's a provision in the governing documents, you should either enforce it or amend it to remove it. Those are the two best options from a legal standpoint. And I want to talk about why that is. There's a doctrine under Virginia law called waiver. Waiver is a legal defense that someone can go into court and assert as to why the association should not be entitled to enforce a provision against them. Under Virginia law, waiver is the intentional abandonment of a provision in the governing documents. In other words, you know it's there and you intentionally don't enforce it. If an owner can provide evidence to a judge that the association has intentionally not enforced a provision in the past, the judge may rule that the association cannot enforce it here. So why is this a big deal? Well, maybe in the past you decided not to enforce it with respect to kind of, innocuous signs. Maybe you said, it says no signs, but they had a little postcard in the window. What's the big deal, right? So you don't enforce it there. Well, next year you get someone with a 12 by 14 foot massive sign in their front yard that contains profanity, and you say, geez, we got to go into court and enforce this. Well, you can bet that owner with that big honking sign is going to cite the fact that the earlier year you didn't enforce the sign ban with respect to the postcard size sign. And there's a risk to the association that because it didn't enforce it in the past, the judge would find that the association waived the provision. That is why I always recommend, if you have a provision in the governing documents, you should enforce it, or you should amend the governing documents to change it or remove it entirely. That is the best legal advice, because otherwise you get into the law of unintended consequences. And a lot of times people say, well, what's the big deal if we don't enforce it in this case? Well, in this case, it probably isn't a big deal. But the law doesn't take into account just this case. You're setting your association up for trouble down the line with those more extreme cases. In the slide, I also talk about doctrines such as estoppel and modification. Owners can try to go into court and cite a prior course of dealing and try and argue that as a matter of equity, the association should be judicially estopped or prevented from doing something differently in the future. With modification, owners can try and go into a court and argue that the association has altered a governing document, has modified it through a course of conduct. So these are common defenses that we see owners assert here. And it's this really goes to why you'll always see attorneys say you should either enforce it or amend it. Don't just leave it in there and not enforce it. Rich, anything you want to
I think
add
that's
on
that's
that point?
all good stuff. I mean, at the end of the day, again, it comes back to rules enforcement, and rules have to be made in a way that they are enforceable equitably across the spectrum. And I would argue that they shouldn't be, that detailed or specific that makes enforcement tough, because then you're just opening yourself up for exactly the kind of scenario Will just outlined.
Yeah. Well, we're nearing the end of our presentation. I don't think I have anything more on my end. Rich, anything else you want to remind the owners or throw out as food for thought?
I would just say, I'm kind of glad that we did this now instead of we were supposed to do this in March of last year before the last national election. So I'm sort of glad we dodged that bullet. But I would say this, that this is a situation that is not going to go away. I think that the political signs and this kind of thing will be more prevalent as time goes on. And so every step you take along that way is going to dictate how you're going to be able to address that issue going forward, whether you can enforce, whether you're going to abandon enforcement, whether you need to work with your attorney to amend the enforcement of the rule and the reg. But everything you do is going to have an impact on how that rule will be enforceable. So really make sure that everybody's on board with what the rule says and what you're going to do to enforce it.
Good words. Well, thank you everyone for joining us. We are at the conclusion of the presentation. I'd encourage you all to check out the PowerPoint slides if you had not done so. And I think, speaking for both of us, if you have any questions that you want to reach out to us about as follow-up, I'm more than happy to answer them. I'm sure Rich
Absolutely.
would be as well. So thank you for joining us, and we look forward to seeing you in person next year.